Greetings. Next slide, if we can. So my name is Rob Dyke. My talk is entitled How to Disclose, Never Disclose Until Broken Cyber Law is Fixed. So let's do the obligatory a little bit about me. Next slide, thank you. This is me, robdyke.com, GitHub, etc. Long-time open sourcerer, worked in the NHS for a while. The app you can see in the background there is called Open EOBS, which is something that we made, an open source nursing observation system. Pretty proud of that. Patient safety and open source, not normally things that people thought would go together, but we made one. Next slide, please. Thank you. I also did this thing. We were talking earlier about smart cards, which reminded me, I made an operating system for the NHS. Wasn't that hard. Put a nice skin on Ubuntu, and that's what we made. Made that in response to the WannaCry events, which I've heard spoken about as well already this afternoon. That was good fun. And next slide, please. These days, I'm Chief Platform Engineer at Capgemini, and when I'm not hacking at work, I'm hacking at home as a bit of an amateur health apps researcher. Something there in the background, I've found some open Firebase URLs. We've all done it, haven't we? We've all left it open, but found those by accident, reported those, and that report went extremely well. But I'm here today to talk to you about some broken cyber law, about what happens when it goes extremely badly. Let's move on one. Thank you. So, and another one. So, how it started. I'm going to tell you a little story, next slide please, about what happened when I discovered some public code on GitHub that had all the bad things that you shouldn't put on the internet on the internet. I found this quite by accident. I wasn't using a particular tool, wasn't doing those mass scanning where people search for API keys or buckets or anything like that. I found it quite by accident. First of all, I didn't actually really believe that what I'd found was real. It's about verifying what I'd found. I managed to identify the owner of the repository and managed to verify the authenticity of some of the contents of that. Next slide, please. And after doing all this this investigation, I was able to ascertain that an organisation set up by NHS England to support open source and open standards in the NHS in healthcare had accidentally leaked all of their secrets for one of their line of business applications straight on GitHub. Next slide. So this was obviously a bad thing, and because I knew the organisation, I thought I would write this up as a disclosure, help them out, write it up with information about the repos, where the secrets were hidden in the code. I also did some investigation into the framework they were using, which had some, as you can see, there's some SQLi and some RCE vulnerabilities there. And I thought I'd written up a really nice report and send it over to them. There's a little example of it there. Not the real one. I'll get in a lot of trouble if I post the real report on the internet. Next slide, please. So I thought just sending this over would be simple. Send them the report. They said thank you. They took the broken application off the internet and they took the code repos private. Brilliant. Obviously, if you've had your usernames and passwords and API keys on the internet for 2 years, you can consider that they are compromised. A little bit taking them down from the internet. It's a little bit like closing the stable door after the horse has bolted. But it was good to see how swiftly they responded to the report coming into their info at address. Next slide, please. Thank you. So, and I thought nothing of it until about a week later, I received this in my mail. The correspondence from Aperta's lawyers said that I had committed various offences under the Computer Misuse Act 1990, possibly committed offences for stealing intellectual property, may have committed offences under the database regulations that exist because of Brexit, and they demanded some undertakings, which was a bit of a surprise because I wasn't really expecting this after being thanked by the organisation for helping them out with this one. Next slide, please. So I wrote a bit of a fulsome response, initially along the lines of, your clients put it on the internet, I've just helped them out a little bit by telling them that they've done a bad thing. But I figured that because the lawyers were quite firm in this correspondence, I had to respond unequivocally. So I gave them some confirmations back. It's a normal thing, right? We do a disclosure, we get letters from lawyers. You'd hope not. But I gave them those 5 undertakings, and I thought that's quite clear. But it turns out that it wasn't quite clear. Next slide, please. They were not happy. The lawyer had latched onto this one word, the word compromised. I mean, I'm in a room I'm not in the room. I'm in a room of SEC professionals. I mean, if I was to say to you, your usernames and passwords are on GitHub, should that be considered compromised? Yes, that should be considered compromised. Not that I had compromised it, but the application and anything around it, anything that uses those API keys should be considered compromised. Next slide. And within an hour of receiving that email, I received another bit of correspondence that says that I was boasting of my unlawful extraction of the data and have threatened to access the systems again. This was because I tweeted that tweet on the previous slide, and then the horse was bolted. It was getting a little bit preposterous quite quickly. The lawyers were really on me with this. Really coming on hard with this unlawful activity bit. And I was starting to get quite worried at this point. Next slide, please. Because there's this last bit here. Please advise how we may serve your solicitor. So I'm getting worried now. I don't fancy having an injunction served on me. I don't fancy being taken to court for helping someone out. So I figured that I could no longer bluster through this by Googling how to respond to lawyers' letters, and I had to ask for some help. Next slide. So I did. I reached out on InfoSec Twitter and asked for help. I said I need to find a cyber savvy lawyer that can help me respond to this because I don't know what I'm doing. Thankfully, InfoSec Twitter family is awesome and friendly and welcoming to newbies like me, and overnight I'd been put in touch with 3 competent cyber experienced lawyers, including someone who works for Google doing their representations. EFF got in touch. They helped out and pointed me in the right direction. Some of you may be aware of Open Rights Group and the No to ID campaigns in the UK. They got involved. They helped me out quite extensively. But these things had a cost. And when I received the estimate from the lawyers, I knew that I wasn't going to be able to support this entirely myself. So I did throw up a GoFundMe for initially a few £1,000 because I thought 1 letter by reply and they'll go away. Yeah, that's not what happened in the end. So we'll carry on. Next slide, please. The letters from the lawyers kept on coming to my solicitors that I'd appointed. I was being asked for undertakings initially that they had received. Then they wanted a statement of truth, which my lawyer had no idea what it was. But we offered again the undertakings that had been given. And they gave me one final chance to do it. All of this high stakes language all the time. If you aren't doing it, then we're going to take legal action, and it's going to get very bad for you very quickly. Next slide, please. So after a couple of days, with my solicitors, this is just the first statement. But the confirmation of facts that I produced with my solicitors ran to something like 11 pages of clearly stepping through what I had found, how what I had done with it when I found it, who I had advised about it, all of these sorts of things. And then it started to get even sillier. As you can see here, they were asking me to destroy documents that I produced, or things which I thought was a bit preposterous, because I had done some work with them on open source projects in the past, and now I'm getting pressure to delete materials that I've been told that Aperta have revoked my open source license to use them. But it was getting deeply technical and deeply into these definitions all the time, and every time we offered a confirmation, they wanted something new confirmed. Next slide, please. And then it went quiet for a few days, and then I received an email from a Detective Constable Specialist Cyber Investigator at Northumberland Police. It appeared that Aperta had reported my disclosure to them as a cyber crime and was about to be investigated for whether or not I had committed an offence under the Computer Misuse Act. I'll go into some detail a little bit later on as to what possible offences I could have committed. But yeah, I elected to not speak to the police. I asked my solicitors to have the conversation first. And for a couple of weeks, the lawyers and the police officer went back and forth before confirming that there was no case to answer, and this was a civil matter that had been referred to the police seemingly for vexatious or malicious purposes. Thank goodness, because you don't really want to do a good Samaritan thing and end up with a criminal record. Next slide, please. this got written up quite extensively, this experience that I was having, and I thought I'd paste some of the links to the articles here for people to look at later, because this whole incident began to shine a light on the problems that independent security researchers face when working in the UK. And it coincided with the 30-year anniversary of the Computer Misuse Act. That's right, we have legislation for cybercrime on the statute book that's older than Google. 23 years. With the Computer Misuse Act being considered not fit for purpose, there was a campaign going on. It got picked up by these orgs and written about. The best thing to watch if you have time, I can't show this for reasons that will become clear, but the best thing to watch is the video, because the video put some third-party verification on my claims. I had claimed that there was a repo with information on the internet, and SIC codes and the Sakura Samurai people found the repository in the Internet Archive Wayback Machine, downloaded it, and verified the contents. Yeah, thank goodness for that, because I was beginning to feel that I was not being believed. Next slide, please. Which is just an overflow of my CSS. Boo! Can I have the next slide, please? Thank you. So, as I said, I can't really talk too much about the contents of the repository, because after the police had closed their investigation, Aperta came forward with some documents that indicated they were going to take me to the High Court and secure an injunction that would prevent me from disclosing what I had found. This, you remember, being the materials that I've already said I won't disclose, that I've already said I have deleted, and yeah, it was preposterous, really. But to receive the threat of a High Court injunction and to have the looming costs of nearly £60,000 or £70,000 to turn up to court and defend myself, I couldn't stomach that. So I entered into an undertaking with Aperta in lieu of going to the High Court, and I am not allowed to talk about what I obtained. Not that I obtained anything, but I'm not allowed to talk about it. So do watch the video, because it's hilarious. Next slide, please. So I wanted to now maybe talk a little bit about why that is so awful. How can it be that I can go from doing a good faith public Samaritan act? Hey friend, you've left your passwords on display on the internet. You might want to change that. And how you get from that through to huge expense and potentially even more, and fear of a criminal record. Next slide. Because when cyber law in the UK goes wrong, these are the sorts of things that can happen. There was over 500 emails back and forth between my lawyer and their lawyer, always clarifying points, and every one of those has a cost, right? Lawyers don't work for free. They don't work on open source projects for a reason. No matter how many times I gave an undertaking, it didn't seem to get right. So this is probably one of those debugging sort of things. Maybe it was a law as code problem, but trying to get a satisfactory undertaking agreed took a long time. Thus, ever increasing the costs. 25,000 UK was is where I've got to in these costs. Thanks to the awesomeness of InfoSec Twitter, about £15,000 of that has been covered, including very early on in the whole experience, a sizable contribution from a well-known corporate that seemingly don't like it when security researchers who are trying to improve the security of the GitHub community, they don't like it when they get picked on. So know that GitHub has got your back, kids, when it comes to these sorts of things. On the plus side, I did make a lot of new friends. And so I've spoken with a lot of people about how cyber law could be improved in the UK. So making some friends was great. Getting the legal support was brilliant. But having to have a couple of weeks off sick with stress, I mean, I couldn't focus on my work. Couldn't focus on a lot of things because it was seriously some stressful time, particularly when it looked like I was heading to the High Court. 177 pages of materials were prepared by Aperta for their injunction. It seems that they'd printed out every tweet I've ever sent and all of every GitHub repo that I've ever made, but they were serious. 127 pages of legal document does not get made for free. So if my costs were 25,000, I'd hate to think what their costs were. Thank you. Next slide, please. So if that's the sort of pressure that you can be under when it goes bad and the sort of costs you can be up against, let's have a few minutes now to talk about what needs fixing and how we might go about that in cyber law. Next slide. So as I said, the Computer Misuse Act is 30 years old. It is not really fit for internet age. There has been a campaign in the UK led by an industry alliance, including Tech UK, NCC Group, Rapid7, and a couple of other well-known security brands that have been lobbying Parliament to review the Act and in order to make it fit for internet time. Next slide. In particular, these are the three things that I think are broken. People who act in good faith or people who are acting in the public interest are not protected by the Computer Misuse Act. So if you are a cyber researcher looking into health apps, such as the COVID-19 app that when that was published, if you had downloaded that APK file and had a look inside it, you would be falling foul of the Computer Misuse Act for unauthorized tampering with a system. Even though you had no intention of breaking it or stealing from it or in any way trying to compromise it in the black hatting kind of sense, you are not protected. Although there has been guidance issued to courts and to the Crown Prosecution Service around clarifying intent, did you intend to break in to steal something, or were you trying to be a helpful kid? That's not on the statute book. There is no obligation for public interest or good faith considerations to be made. So this is a bad thing if you are doing cyber research, either as an independent or indeed as a corporate in the UK. It can also be weaponized to intimidate. The complaint made to the police is a good example of that. I got off lightly with the police complaint. There have been other cases in the United Kingdom recently where a community group campaigning against a property developer and a development of the local area. The campaigner group found on the internet an open Google Drive with some docs in it that gave their the property developer's internal view of the project, which, how should we say, was somewhat different from the public view. The campaigners used this document in order to strengthen their objections to the local authorities. But the campaigner received a visit from the police, who raided his home and confiscated his machine because he was the Google Drive. The organization had persuaded the police that it was a private computer system, and because he did not have authorization, he had stolen those documents. So he found these documents by accident. The property developer then weaponized the police to intimidate them, to try and silence the critics. There have been other examples as well, but I think that's a really that one plus myself. I think they show how there is a need for the police to have better tools at their disposal when investigating cybercrime. It's also financially ruinous. So I've spoken about my costs and Aperta's costs, but let's think about it. What that means on the other side. It means that if you've got money, you can win in cyber law. Another case from earlier this year, a law firm secured an injunction against persons unknown to say that to prevent them from publishing data that had been exfiltrated in a ransomware attack. Now, you can only get that sort of justice if you can afford it and if you've got deep pockets. In the same way that I was having problems with my own costs, it seems if you've got an insurance company or if you have a really decent legal fees budget, you can buy whatever whatever action you want under UK cyber law. Next slide, please. So that's what's wrong. These are the offences that are currently listed under the Computer Misuse Act, and these are you can see that these are perhaps not really internet savvy. So causing a computer to perform any function with the intent to secure access that you're not authorized to. I think we can understand what that is, but also these things can also happen by accident. You can log in and to a system and have rights that you may not that you're not supposed to have. So there's all of this. There are lots of. Sorry, I'll come in again on that bit. This causing a computer to perform a function is a challenge for security researchers, because when we use tools like Nmap or Burp Suite or other scanning tools, you are at risk of falling foul of that clause. Because you are interrogating a system without authorization. There is another offence there. So if you commit, if you're doing something under offence 1, which is perhaps a reconnaissance piece, and then you are using that to commit further offences. So this is compromising a system and then using it to defraud people. I think that's that one's probably okay as a bit of cyber law. We can understand that. I compromise a system in order to embed some malware, mage cart, those sorts of things. So I'm committing fraud after I've compromised the system. But it's this one here. It's this third one that is really a problem. Uh, so it's good insofar as it can cover things like denial of service attacks or malware and things like that. But again, it can also cover um, good faith, independent, public interest researchers. You can very quickly find yourself falling foul of these three. The third of these offences as an independent security researcher. Next slide. So, knowing that it is broken, the UK government opened an RFC, which was great. I had the opportunity to respond because I figured that my experiences really should not happen to another person. Anything that we could do, that I thought I could do in order to shape an amended Computer Misuse Act to incorporate protections for cyber researchers and to prevent the criminalization of developers that make either proof of concepts or release tools for discovery on GitHub. I thought that I would respond to those. The actual response, the call for response has now closed, and we're waiting for the government to publish the list of responses. In addition to the Computer Misuse Act, next slide, please. In addition to some of the missing slide. In addition to reform of the Computer Misuse Act, I think another thing that needs fixing in particular is the guidance that the NCSC have issued on security incident response. Instead of it being guidance for public sector organisations, I'd like to. I think that needs to become a mandatory sort of operating procedure. Some public sector organisations in the NHS in the NHS in particular, do extremely well with their cyber response. Where they have public code, they have a security.md, and they invite both public bug bounty program participants and independent researchers to get in touch with incidents. And because the final slide appears to be missing, I don't have my pithy little quote on the end, which is a bit of an annoyance. So those are the two things that I wanted to talk about with what needs fixing. I thank you for listening.